Good morning, everyone. Welcome to the breakout session on implementing of the United Nations Declaration on the Rights of Indigenous People. My name is Bobby Greenland Morgan, and I'm here today from Inuvik. I am the current president and Grand Chief of the Gwich'in Tribal Council. It's a pleasure to be here today and to participate as a moderator in this very interesting session we're about to go into. I'd like to welcome all the speakers and thank them for taking the time today to be part of the panel. We have Ms. Lorraine Land as our first speaker, and then we have Brenda Gunn. She's the Associate Professor of the Faculty of Law, University of Manitoba. Then we have Mr. Craig Benjamin, Indigenous Rights Campaigner with Amnesty International, and Ms. Diana Kwan, Senior Counsel at Justice Canada. Implementing the United Nations Declaration on the Rights of Indigenous People is a focus of the federal government. Building on yesterday's discussion of consent and consultation, this panel will follow up on that and ask what are the often overlooked aspects of the Declaration and what does it mean for modern treaty holders. We will begin today's session with lawyer Lorraine Land. Please welcome Lorraine to the podium.
Thank you, Chief Bobby Joe. Good morning, everyone. My name is Lorraine Land. I'm a partner with the law firm Olthius Clear Townshend, and we serve Indigenous communities across the country, coast to coast to coast. A lot of my practice is in the Northwest Territories, Northern Alberta, and Ontario, and I have some background in Nunavut. First of all, I'd like to, of course, say thank you to the Algonquin on whose traditional territory we are today and who welcomed us to this conference, and also a thank you to the conference organizers. I was saying to them this morning, I can't believe what a well-oiled machine this conference is. I'm sure behind the scenes they have stuff going on, but what a great conference it is from a participant's perspective. So it's an honor to be asked to participate in this panel. I certainly don't profess to be an expert on the UN Declaration. The perspective I bring is the perspective of somebody who's working in the trenches, so to speak, with Indigenous communities who are looking at what kind of tools, if any, the United Nations Declaration provides in achieving the goals, the rightful goals that communities have for self-determination. I'm glad to be on a panel with some of the experts who are here from Amnesty International, for instance, and their amazing campaigns around these issues, and with Professor Gunn, who's done a lot of work internationally and in Canada on this field. So there was another panel session earlier about the free, prior, and informed consent in the context of consultation and consent. I'm not going to talk so much about FPIC in my presentation. I want to talk about how we move beyond talking about just FPIC, because a lot of the focus in Canada has been on free, prior, and informed consent. It's fed into a lot of fear about the implementation of the UN Declaration. One of the things that I've sometimes talked about is an acronym, FEAR, F-E-A-R, I sometimes think of as false evidence appearing real, and there's a lot of false evidence about FPIC, a lot of fear-mongering about it. Often consent, if you think about UNDRIP as a tool, the United Nations Declaration as a tool, and what the tool is that FPIC would be, sometimes you get the sense that consent is like a big bag of dynamite about to blow up all developments, or that an Indigenous veto is going to hammer away at proponents and create destruction. Those are the kind of tools that I think are in the public consciousness about FPIC. I want to talk about what kind of conceptions we can be using for FPIC as a tool more generally, and what kind of tool the United Nations Declaration as a whole is. And when I think about the fear-mongering that goes on and how we need to move away from that, I think about the recent Clyde River decision of the Supreme Court, where I had the opportunity to be in lockup when the decision came out because I had represented the Inuvialuit as one of the interveners in that case. And the Inuvialuit's intervention was about using UN Declaration principles. And I came out of lockup and walked right into a television interview with the Business News Network, and all I could see across the news feeds was about how these decisions were about how Indigenous peoples had no veto, which I thought was very strange, given the fact that that was about paragraph 52 of the second decision. But it's indicative of what are the messages that the broader culture is looking for. So then what kind of tool is the UN Declaration? I think we can think about the Declaration as a whole as a compass. When we're talking about land claims implementation, it's a way of assessing where we're at, the direction that we're moving, and achieving some of the underlying principles in the UN Declaration. And the UN Declaration, in the totality of the principles, I don't know about you, but every once in a while I have to step back and actually go back and take a look at the UN Declaration as a whole, because there's a lot of content there. And it's good just to take the opportunity to go through and look at those articles, and I encourage you to do that, because when you take a look at it as a whole, it's a far more nuanced approach to Indigenous rights than what we actually often have in the discourse in Canada, and particularly from a legal perspective, dealing with communities. And when I think about this, I think about a tension that many of us who are working at the community level often experience when we are working with these issues, which is, as you know, when issues come up, for instance, questions about development, what communities are trying to achieve is protection of a way of life. I recently came out of a couple weeks of National Energy Board hearings in the last couple weeks up in Fort Simpson, the territory of the Kliklikwe First Nation, the Dene in the Northwest Territories. And we heard the community members talking about how an Enbridge pipeline replacement project was a concern to them because of the way of life. And on the other hand, you had the National Energy Board and the proponent Enbridge trying to figure out which of the checklists of the Section 35 harvesting rights could be impacted. And there's this fundamental tension there. And often we feel that tension when we're working at the community level. I'm sure many of you do. And I think the United Nations Declaration principles are one way of understanding the much more nuanced understanding of what are the Indigenous rights at play when we look at these kinds of decisions. It reminds me of the opening remarks that were made by the chairs about those fundamental tensions between the hopes and objectives of the land claims agreements and then what is actually happening, because the land claims agreements capture that sense of the desire for continued Indigenous jurisdiction, self-determination, and relationship with the territories, the land, the culture, all those things that are so integrated, and then the disappointment when there's the artificially constrained boxes and legal analysis of Section 35 rights. So some of those implementation challenges that we have been talking about over the last couple of days that are relevant to how we think about how we use the United Nations Declaration as a tool include things like the failure of the Crown to implement specific aspects of the land claims agreements, and not just the ones that have to do with land rights protections or resource revenue sharing, but also the many parts of the land claims agreements that have to do with cultural protections, with education rights, with language rights. A lot of the remedies in the land claims agreements, as you know, tend to be softer on the social issues like language rights, children's rights, and so on, but those are just as visceral at the community level and are a challenge, and I think it's there that the United Nations Declaration and the principles that deal with those issues is relevant. So, for instance, if we use the United Nations Declaration as a compass, some of the things that we can talk about beyond the discourse about land rights and resource rights, which usually dominates our conversation in a Canadian context, and particularly in relating to the Crown, are things like the cultural rights protections for traditional sites, historical sites, ceremonies, performing arts, literature, things like the children's rights protections that are reflected in the Declaration, including the right to establish and control education systems. That includes the right to education in the Indigenous community's own language, and that includes the obligation on the state to provide education in the language and cultural context for children who are not in their own communities. There's language rights provisions. Of course, in the Declaration, a number of articles, other cultural rights, including the right to maintain and strengthen a distinctive spiritual relationship with traditional lands, waters, and resources, which is more akin to that way of life approach I was just talking about that we actually see at the community level being pursued. Importantly, decision-making rights, and that includes the right to participate up front in the decision-making about all matters affecting rights, including legislation. That's relevant to the discussion that just happened with the deputy ministers who were telling us about what the federal government is doing on its side to implement the United Nations Declaration without that really being a discussion from my perspective about how that is an Indigenous-driven process, because the rights holders here are not the state. It is not the state that holds Indigenous rights, it is the communities, and it's the communities who should be determining what the implementation agenda should be. Not the state consulting after the fact about the beautiful principles that may be applicable and how to squeeze that into the existing regulatory and legislative framework. The UN Declaration, of course, also deals with things like economic and social development rights, the right to the highest attainable standard of physical and mental health. So for those who live and work in the North, we know that that is a consistent issue, for instance, in terms of the lack of services in those areas available to people at the community level. So I'm just going to skip through quickly a few examples of where the United Nations Declaration articulation of these rights is applicable in a very practical way. We had some of the presentation this morning by Lena Ivik about the amazing Peruvic program and the language and culture programs that they are implementing, but you heard her talk about how there's no systemic institutional support for that work, no culturally appropriate accreditation program, there's jurisdictional issues. There's been a lot of stuff that's been happening that's positive in Indigenous language protection, including recent announcements of federal funding, but we still have issues like the debate happening in Nunavut right now over Inuktitut education rights in the school system, and some concern about the latest census results showing the decline in Indigenous languages in the Northwest Territories. Education rights is another example where we can be looking at the principles in the UN Declaration to deal with, for instance, some of the deep training needs of communities. Some of that was, of course, a key issue in Nunavut Tungavik's legal challenge against the federal government for lack of implementation, and now we have NTI working on its own to implement the type of training programs that were envisioned to be the ones that should be funded by the state through the implementation process. There's the right to benefit from resources. That includes the right to redress where there is an impact that is not able to be mitigated. Again, just to use an example from the National Energy Board process I was just participating in Fort Simpson is a good example where on the one hand, even in the devolution process, both the federal government and territorial governments cry poor about being able to flow funds to communities through the devolution process. We had evidence in that hearing that over the last 30 years, not from resource royalties, but just from its share of the profit of that original IPL, now Enbridge pipeline, the federal government has earned $1.6 billion, and there is a fraction of the resource royalties, which is a fraction of the $230 million for that project that is now flowing to some of the Satu communities and not at all into the Decho Dene communities. And there are the provisions, of course, about cultural and spiritual sites. I'd encourage you particularly to look at some of these. There's a number of provisions in the UN Declaration, including the rights to practice spiritual traditions, but the right to maintain a spiritual relationship with traditional lands and resources. And as has been talked about before in the last couple days, this is up against the very troubling decision that just came down from the Supreme Court 2 weeks ago in the Tunaha case out of British Columbia, where there was a very culturally embedded blindness to the need to recognize what the Indigenous spiritual rights should be in that context. Very troubling decision. So just in the last minute and a half I want to talk about a couple of the practical implications of all of this if you use the UN Declaration as a compass. As I said, remember who holds the tool. Who has the rights? It's the Indigenous communities who should be driving legislative reform processes. We heard some discussion this morning about Indigenous laws, some very practical examples of where that could be implemented in a systemic way include in, for instance, Nunavut, where you used to have elders who were actually on staff at the ministerial level in departments to advise. And certainly when I was the director of the Legal and Constitutional Branch, I used to turn to the elder for advice. That is a practical example of something that no longer exists. Or the language requirement that used to be in place in Nunavut, for instance, for senior officials to be fluent in Inuktitut for senior deputy minister positions, for instance. So those are examples of where the land claims set out a vision and we've had slippage and where we can be working. There was some discussion about the split within the Department of Indigenous Affairs, and that's something I would urge us to be cautious about, because one of the problems that we have is the lack of implementation of the soft, so to speak, social rights in the land claims agreements, cultural rights, children's needs, elders' needs, and so on. And when you split the relationship department from the service implementation, service delivery department, you set up a problem, which is the disconnection of the delivery of those programs from the relationship. And a good example of that is the situation that we've had with the Canadian Human Rights Commission decision on Indigenous children's rights to funding for children protection and education and other programs where that is still not being enforced despite multiple appearances to try to get that Human Rights Commission enforced. And finally, things like the need for an Indigenous Languages Commissioner at the federal level. The land claims area communities have been calling for that. A national sacred sites protection approach and legislation, that has been something that has been waiting implementation. Partnership up front and not consultation after the fact in legislative reforms, for instance. And finally, I want to conclude by saying, so if you're thinking about what kind of tool is the United Nations Declaration on the Rights of Indigenous People, and it's not the dynamite that blows up projects or the hammer for hammering proponents in government, I think the tool that the United Nations Declaration is instead the circle, the Indigenous concept of the circle, which I think captures the type of participatory, democratic, relational, holistic way of life integrated approach that's more consistent with an Indigenous perspective. And so that's the kind of tool I'm hoping that we can think of the United Nations Declaration as a tool for building the circles of reconciliation in very practical ways. So those are my comments. Thank you.
Thank you very much, Ms. Land. Very good time management. You were right down to their 15 minutes. Next, we will hear from Ms. Gunn, Associate Professor from the Faculty of Law, University of Manitoba.
Okay, perfect, thank you. Good morning, everyone. I'm really grateful and a little bit nervous to be here today presenting to all of you. I just want to start by acknowledging the traditional territory and really thank the Algonquin for allowing us to be here. And especially as a Métis woman from the prairies, you know, it's really important that we acknowledge, I think, their sacrifices that they've made for us to be here today. I want to really thank the organizers for putting on a great conference, as Lorraine said, and also my co-panelists. And I will say I was nervous before, and now Lorraine just gave a fantastic presentation, and so I think that has managed to make me a little bit more nervous. And I think part of my nerves this morning is, as I said, I'm Métis, I come from Manitoba, I live in historic treaty territory, and to be honest with all of you, I have very little experience working with modern treaties. I'm pretty sure I've never been in, well, maybe some in BC, lower mainland area, but I've never really spent time in modern treaty territory. And so I'm kind of thinking, well, what do I have to offer to this crowd? And so my expertise is really on thinking about what is the role of the UN Declaration internationally as well as domestically, and how can it help us move forward? So what I posit today are more just some of my ideas for how I think the UN Declaration may be relevant in a modern treaty context. And I want to think about how can we use this in what's also a new context for me. So I hope my thoughts are useful for all of you today. So when I was thinking about this idea of a tool, and in case it's not obvious, I think it is a tool and not a distraction. I think it's a really important tool. And why do I think that? When I look at the preamble, it tells a really, I think, important story. And I think it's picking up on what Lorraine said, is that the UN has finally recognized Indigenous peoples as peoples, that we are Indigenous and have a right to be treated and have the same fundamental human rights as all peoples around the world, but that we also have a right to be Indigenous and to protect our ways of life and ways of being. And so the UN has recognized that colonization has a negative impact, particularly where colonization has removed Indigenous peoples from their lands. The UN Declaration then goes on to talk about how, by working together, Indigenous peoples and nation states, we can actually start to reset the relationship, moving beyond the current colonial context where the Canadian government asserts control over Indigenous peoples in many circumstances, to a new relationship where Indigenous peoples are working with the federal government, and a new relationship that's now based on principles of justice, democracy, respect for human rights, non-discrimination, good faith. And so I think it's really important then, before the UN Declaration goes into the substantive articles, it reminds both Indigenous peoples and states that the process of implementation is one where states and Indigenous peoples have to work together in a spirit of partnership and mutual respect. So as we go through talking about implementation in Canada, it cannot be a unilateral action of the federal government, but it requires working with Indigenous peoples in order to achieve this new relationship. So as we move forward and think about the tool of the UN Declaration, for me, it's important to remember that the UN Declaration is not the only international human rights instrument that is relevant to Indigenous peoples' fundamental human rights, that it has to work with the broader international legal context. And so there are a ton of instruments that exist out there, some of which are treaties and conventions that Canada has signed and ratified, and they claim at international fora that they have fully implemented into Canadian law and thus are part of Canadian law. Others are general declarations, including the recent American Declaration on the Rights of Indigenous Peoples. And so I think part of the tool that the UN Declaration does is, for those of you who don't want to become an international lawyer and international expert, you don't actually have to read all of the decisions and all of the treaties and sort of have that really broad understanding, that we do have the UN Declaration that really encapsulates, at least at a basic level, all of the generally recognized rights of Indigenous peoples. It's also one of the more recent instruments. So I think just that recency is really helpful, because Some of the other ones are going back 20, 30, 40 years. And so, as I think about implementing the UN Declaration and how it can be useful, I think it's important that we always remember that it applies equally to all Indigenous peoples in Canada. And I'm thinking of this more and more as I see Canadian law makes a lot of distinctions between modern treaties and historic treaties and First Nations and Inuit and Métis, and there's all these different distinctions, and there's somehow, I think, where Canadian law has responded by creating different understandings or different scopes of different rights depending on which system and which Indigenous people you are. And one of the things that we see in the UN Declaration is that the rights are a bit more universalized, although they come and are realized on the ground in very specific contexts. I think there's a need in Canada to make sure that the rights are applying equally to all Indigenous peoples. I think it's also important because of the way in which the UN Declaration reminds us that in Canada we need to really shift the relationship, moving away from the idea that Indigenous peoples are a burden on the state to one where Indigenous peoples are partners in confederation, are First Peoples, and have rights resulting from that. Sorry, I think my time is ticking along very quickly. If I have time, depending how long I talk for this morning, I may come to the bottom point of moving beyond consultation and accommodation to participation in decision-making. And I know it's been talked about a little bit today, but I just sort of wanted to add to some of that. But I think there's a real need in Canada to use the duty of consultation as a starting point, but realizing we're not at the standard or place we need to be at yet. Sorry, I think I'm going the wrong way. Hit the green button. Okay. So as Lorraine has already pointed out, there's a lot of provisions, and it's a very broad and encompassing instrument. But at the starting point, people often start with self-determination as the foundation. And I used to think about it that way, but more and more, I'm recognizing that self-determination is actually Article 3, that 1 and 2 are about equality and non-discrimination. And so what that means is that Indigenous peoples, as I've mentioned, have the same fundamental human rights as all peoples, though how we actualize or implement those are going to depend on the specific context of the Indigenous peoples. And so this will require governments in some circumstances to take positive action in order to ensure that Indigenous peoples' rights are realized. And this, for me, has also, these principles of equality and non-discrimination are also important to me as we start thinking about the modern treaty context. And so what I want to talk about very briefly is just a little bit of international treaty law and then bring that back to the UN Declaration. So it's really important to note that there have been periods in international law where Indigenous peoples' ability to engage in international treaty making was recognized. So Indigenous peoples, for many, many years, decades, centuries, were recognized to have international standing to conduct international relations, including treaties. However, in the modern era of international law, states worked to circumscribe or try to take away that international standing. And part of how they did that was they changed the rules of international law and who could be an actor. And so one of the international treaty law scholars, McNair, made these statements in sort of one of the primary textbooks on international treaty law. And citing a case from an international court that treaties made between Indigenous peoples and nation states are not international treaties. And he refers to this case, right? And he makes this as a very sort of set standard, and you think, okay, that's the end of the story, except then he goes on and makes a little caveat. He says, however, this is just the modern representation of international law. And then, in fact, many of the treaties that were signed between Indigenous peoples and nation states have, in fact, been recognized as international treaties by domestic courts. And I raise this point because it's important for me, at least, when I think about treaties or the historic treaties in my context, The Canadian courts have tried to say that treaties are sui generis and not international treaties. And when I followed the sources that the Canadian courts used, they're actually not talking about Indigenous treaties at all. The only reference, when you trace it all the way back, the only reference was to a case on the Jay Treaty, which is between Canada and the US, and that's somehow the authority that the Canadian courts use for this position. And so I think I no longer accept that decision of the Canadian court because I don't think it was founded in anything other than racism, that Indigenous peoples couldn't have this standing. And so if we move beyond the sort of brief period in international law where Indigenous peoples were not recognized to have international standing, we see the 1999 report by the UN on treaties, agreements, and other constructive arrangements, that the special rapporteur really expressed strong concern about the domestication process of treaties, this idea of somehow taking away that international standing of Indigenous Crown treaties and making them domestic agreements. And I think this is important in the modern treaty context, potentially because the study was initially going to be about treaties and agreements, and at the prompting of the Canadian government, it was expanded to include other constructive arrangements, which was thought then to expand the scope of the study to include modern treaties. So somehow, in this process, Canada has made a distinction, and I think trying to make it a legal one, that there are treaties, and then there are other constructive arrangements, and somehow modern treaties are going to fall into a different category. And I think that would mean potentially an argument that there might be different ramifications. And I think that's particularly problematic if we come back to the UN Declaration, because of the way in which it starts by recognizing the right of non-discrimination and equality. So how can we treat modern treaties as a different legal character than historic treaties? Well, the only way you do that is if we take away a recognition of the nationhood of the one of the parties signing them. And the UN Declaration doesn't make those distinctions, right? The provisions talk about treaties, agreements, and other constructive arrangements, and talks about them holistically. So I'm hoping that as we move forward, if people who are in modern treaty contexts, you know, while there are differences to historic treaties, I'm not sure that we want to call them not international treaties. And again, that's not for me to say, but this is one of the things that worries me. And so it's important that the UN Declaration recognizes that treaties, agreements, and other constructive arrangements may have an international character and may be of international responsibility. And so this has been built upon more recently by the American Declaration on the Rights of Indigenous Peoples, where the American Declaration then goes on to talk about what are some of the competent bodies to hear disputes. And so if we think about including treaties, historic or modern, within the broader international treaty law, it means that potentially that at least one, there's no unilateral modification of treaty. You are unable under international treaty law for one party like the Government of Canada to change the scope of treaties. It also potentially means that Canadian law is not the only or the appropriate source of law to interpret the scope of treaties and any of the responsibilities flowing from the treaties. And it may also mean that while domestic courts may be one of the venues that are available when disputes arise, they may not be the only or the most appropriate venue for disputes to occur. I think I'm probably out of time, and so I will leave it there. I'm trying to see if I have one last big word to say, and I don't think I do. Thank you so much for your time.
Thank you very much, Ms. Gunn. I think the challenge of being a moderator is having to tell people time is up, especially when they're giving a very good presentation. So far, we've had heard from the first two speakers, and I'm just sitting here looking and thinking of a lot of issues that we can all come to mind in regards to Indigenous rights. And for the Gwich'in, the Indigenous group that I am a member of, right now we're up against the U.S. government in one of the biggest fights of our lives as we continue to try to protect our our way of life, and that is through the protection of the porcupine caribou calving grounds, their main birthing grounds, which is in the coastal plain of the Arctic National Wildlife Refuge in Alaska. And we have many different agreements, and even though those agreements, some of them international, it's a big challenge trying to get those people in the big decision-making powers to recognize and honor our rights as Indigenous people. So very interesting. But I'm not a speaker here, so we'll move on to speaker number 3, Mr. Craig Benjamin.
Hi there. So I too want to acknowledge the Algonquin people and the privilege of being here as a guest on their unceded territory. I had a real great fortune and the privilege of being able to attend the UN working group that elaborated the UN Declaration. And it was possible for Amnesty International to enter that space in the final years of the process for 2 reasons. One was the invitation and the mentorship and the partnership of those Indigenous experts and organizations that had been there already for many years in what was a multi-decade long fight to achieve the Declaration. And the other was the opportunity to participate in a coalition of Indigenous and non-Indigenous organizations that continues actually to work in Canada to promote now the implementation of the Declaration. And for me, the starting point was a meeting in Montreal, the first meeting of that coalition. And we had the guidance of 3 experts on the UN Declaration, Kenneth Deere, Marie Léger, and Romeo Saganash. And that guidance, that leadership, meant an enormous amount to all of us in the process of coming to terms with the history of the Declaration and its importance and understanding just why it was so critical to lend our support to achieving this Declaration. This year, as you know, is the 10th anniversary of the adoption of the Declaration at the UN General Assembly. And that coalition marked the anniversary with a public statement which called on the federal government to embrace and build on an initiative that Romeo Saganash has begun, which is a private member's bill, Bill C-262, which is a bill to establish a legislative framework for implementing the Declaration in Canada. What does that mean, a legislative framework? It doesn't mean simply taking all 46 articles of the Declaration and incorporating them in one fell swoop into Canadian law. What it does do is it calls for, would establish a consistent, comprehensive, transparent, and accountable process by which all levels of government in Canada could work collaboratively and in partnership with Indigenous peoples to fulfill the ends of the Declaration. And critically would mean that we would move beyond an age of having to rely on the goodwill of the government of the day in respect to the Declaration. So in my limited experience of the 15 years of work on the Declaration out of a more than 3-decade-long process that led it to this point, I've seen in that time incredible swings and shifts in how the federal government addresses and deals in response to the Declaration. When we first got involved, the Liberal government of the day under Jean Chrétien was an obstacle to progressing with the Declaration. Under the government of the same party, but a different Prime Minister under Paul Martin, Canada became a crucial partner in achieving the Declaration. I think it can be honestly said that we wouldn't have the Declaration without the partnership between Canada and Indigenous Peoples Caucus that helped to pave the way for other states to join that consensus. We saw the Harper government come in and initially campaign aggressively to try to kill the Declaration, to try to rally other states against the Declaration, to misrepresent the content of the Declaration, to promote that fear approach that Lorraine talked about, and then a shift over time to a grudging and conditional acceptance of the Declaration. And today we have extremely good and welcome words being said about the Declaration on the international stage by the current government, but real concerns about the consistency of how the government approaches that Declaration on a whole of government basis. So what are those elements in Bill C-262 that our coalition has called to embrace and build upon? The first is the repudiation of colonialism and colonial doctrines for exactly the reasons that Brenda Gunn outlined. The content of the preamble of the UN Declaration. It's important to see this, again, not just in the words of the government of the day, but to be part of the law of the land. Clear public affirmation that the standards set out in the UN Declaration have application in Canadian law. It's routine in Canada, it's well-accepted principle that Canada's international commitments should inform how our courts interpret domestic law. And courts do this routinely across a wide range of international human rights, refugee law, labor law. It breaks down in respect to the rights of Indigenous peoples. Lorraine mentioned the Tanaha decision, the Clyde River decision. These are places where the Supreme Court was presented with the opportunity to help interpret Canadian law through the lens of the UN Declaration, and chose to turn away from the Declaration and not reference it at all. Lower courts have already used the Declaration, but they've been utterly inconsistent in the way that they've done so. While some courts have used it, other courts have said we see no reason to turn to international law. Having a clear legislated direction from the federal government to say there is an expectation to use the Declaration in this way is clearly needed and critical to achieve those kinds of breakthroughs that previous presenters talked about. The process of reforming federal legislation to ensure consistency with the minimum standards set in the UN Declaration, while there is a process now underway, which I think we'll hear more about as well, to put this into a larger framework, I think is critical, and to ensure accountability. Which goes to the two other key points of this bill that we're calling for the government to embrace and build upon. One is the collaborative development of a national action plan to implement the UN Declaration. A national action plan is by definition one which is comprehensive, which involves engagement with Indigenous governments, but is also with provincial and territorial governments, and the key word there in this being collaborative. And accountability is key as well. So the bill calls for regular reporting to Parliament on progress made in implementing the UN Declaration. I think that opportunity for Parliament, for the Canadian public, to be able to see and to be able to engage in a conversation about the progress being made, about the directions being taken, is important as well. And this approach, to go to Brenda's point about the interrelationship, how international human rights standards are interdependent. The UN Committee on the Elimination of Racial Discrimination, which is an independent expert body that oversees Canada's compliance, or all states' compliance, with international treaty on the elimination of racial discrimination. It reviewed Canada's record this summer. In its final report, one of the things that it called upon Canada to do to fulfill its obligations under that convention, on the elimination of racial discrimination, was to adopt a legislative framework for the implementation of the UN Declaration, one that would include a national action plan, reform of national laws, policies, and regulations, and annual public reporting. And then a final word from me on a national action plan. And this is where I think that we have real space to build upon the work that's begun with Bill C-262. This phrase is up on the screen. This is a definition of a national action plan that to be systematic, comprehensive, multi-sectoral, and sustained, adequately supported, facilitated by strong institutional mechanisms. This is part of a UN General Assembly resolution calling for states to adopt national action plans on violence against women. But it serves, I think, as a good definition of the essence of a national action plan in all contexts. And interestingly, this is a resolution that Canada led at the General Assembly and championed, and I suspect actually wrote, it was Canadian representatives that drafted that language. And so I'll conclude there.
Thank you very much, Mr. Benjamin. Speaker 4, our last speaker on the panel, Ms. Diana Kwan, Senior Counsel at Justice Canada. Following Mrs. Kwan's presentation, we will have about 10 minutes 10 to 15 minutes of a question period. Thank you.
Good morning, and thank you very much to the organizers for inviting me to speak this morning. I'd also like to acknowledge the hospitality on the territory of the Algonquin Nation. So, speaking of nervousness and intimidation, I'm the federal government representative after a very illustrious panel of a very distinguished practitioner, a very distinguished professor, and a very distinguished advocate. Yes, no nervousness here. Okay, so what would I like to talk about? I think it's worthwhile to spend a little bit of time. I mean, the question, the way I've approached this particular presentation, again, is very much on this issue. Is the UN Declaration a tool or is it a distraction? And I have to say, I've actually gone back and forth on this question quite a bit, even during the course of this morning and listening to my other panelists. So I'm going to put out my first kind of position on whether it's a tool or a distraction, and then I'll just let you know how I got there. So tool or distraction, I actually think it's both. And the reason why I think it's both is actually starts with context around the UN Declaration itself and Canada's related support to it. So I think as Craig spoke a little bit briefly to the history of the UN Declaration, it was adopted by the General Assembly in 2007, a very long, extensive international series of negotiations that led to that point in time. And Canada, at that time in 2007, was actually one of the 4 countries that did not support adopting the UN Declaration, even though it had been one of the key partners in the negotiation process. So Canada at that time stressed that the final text actually never addressed Canada's concerns, and it didn't actually address Canada's continued commitment to advancing the rights of Indigenous peoples. So fast forward 3 years later, after 2007, in 2010, Canada issued a limited statement of support for the UN Declaration. And that came out of kind of an evolving context. In 2008, the Prime Minister at the time issued an apology to Indian residential school students in the House of Commons. It was quite a historical thing to do at that time. There was also a very strong emphasis on an emerging and growing legal policy framework that was being developed by the government at that time for the protection of Aboriginal and treaty rights. So there was a bit of an evolving context. That led to the government in 2010 releasing a limited statement of support, and their statement was this. They said that the UN Declaration was aspirational. They said at that time it was a non-legally binding document, and it didn't actually reflect customary international law or change Canadian laws. So that was 2010. Fast forward another 5 years, and we have a new government, a Liberal government. And this particular government was very bold and very ambitious when it stated that it had a commitment to a renewed nation-to-nation relationship with Indigenous peoples based on recognition of rights, respect, partnership, and cooperation. So one of the first things that it did, and largely it was based on partly the Truth and Reconciliation's calls to action on adopting and implementing the UNDRIP, the UN Declaration, one of the first things it did in May 2016 with respect to the UN Declaration was announce that it is a full supporter without qualification of the Declaration. So what does this mean? So we've also talked a little bit about the UN Declaration itself this morning, and we talked about the individual and collective rights of Indigenous peoples and how the UN Declaration covers a very broad range of issues, and that includes lands and territories and resources, huge emphasis on self-determination, economic, social, political, cultural rights, civil rights, and of course free, prior, and informed consent. So lots packed in a declaration like that. So in working for the government and providing advice and trying to kind of narrow the scope and focus of what the UN Declaration is, I tend to focus on 3 main points about the UN Declaration. So my first point about the UN Declaration that I like to focus in on when I'm talking about it with colleagues and providing advice on it is that collective Indigenous rights are treated as human rights. So this goes to Brenda's point about how the UN Declaration very much focuses on a human rights aspect to Indigenous peoples and how they need to be regarded in our society. So a second point about the UN Declaration that I emphasize is very much on the point about self-determination. The core of the UN Declaration is on self-determination. The third point that I focus on, and this is one of the articles in the UN Declaration which says that all the rights contained in the UN Declaration are integral to cultural survival. The flip side of that, and I think this is the side that I find quite compelling, is that the government has to absolutely play an active role in enabling, not just recognizing, but enabling the exercise of these rights. So in this respect, I think the UN Declaration can very much be a tool, but as you can see through a changing political context, it can also be a little bit of a distraction. So where do we go from here? What is the active role that government has taken with respect to the UN Declaration? I think you've heard from some of my federal government colleagues earlier today or yesterday about the different ways and means of implementing the Declaration. But I think one of the key ways and means that we're implementing it is through a very comprehensive review of laws and policies. This is led by a working group of ministers, and that working group of ministers is chaired by my minister, the Minister of Justice. And their work is being primarily guided by a set of principles, and these are the principles that were released in mid-July. They're titled the Principles Respecting the Government of Canada's Relationship with Indigenous Peoples. So the review of laws and policies, what is this driven by? Partly it's driven by, do we really do what we say we believe in? So partly that's from Section 35 of our Constitution, which has all these values in it, has all these protections for Aboriginal treaty rights. But I think, and I think this room would probably definitely agree, the implementation falls down. We don't necessarily live up to what we say we actually believe in. So how does the review of laws and policies help? How do the principles play, and how does the UN Declaration help? So the principles themselves, they are very much a starting point for government to shift their own baseline for how they will interact with Indigenous peoples. I think it is very fair for me to say that government has a lot of work in terms of cleaning up its own house and proceeding forward with work with Indigenous peoples in the relationship. So these principles are meant to help them. While the work is primarily meant to guide the work of the working group of ministers in the review of laws and policies, it very much kind of changes the direction for which government should be proceeding. So the principles themselves, they're rooted in Section 35. They very much reflect a lot of the Supreme Court of Canada jurisprudence, very much informed by the UN Declaration, and to the extent possible, they pick up on some previous reports that were done before, such as the Royal Commission on Aboriginal Peoples and the Truth and Reconciliation Commission calls to action. The other thing about the principles is that it very much focuses on a recognition-based approach. The principles themselves fully recognize Indigenous peoples, as having governments, laws, a relationship to lands and resources, and it affirms very much the right to self-determination and the inherent right to self-government. The principles, there are 10 of them, they cover 5 main themes. They shift relations to a basis of a recognition of rights. There's a very, again, strong emphasis on self-determination and self-government. Third theme of the principles is that it does focus on a renewed approach to negotiations and relationships with far more innovative and flexible approaches. There's some confirmation of some of the past statements, such as reconciliation is the fundamental objective of Section 35, and to the extent that it is necessary and possible, it takes a distinctions-related approach, which is to say that it pays attention to the differences between First Nations, Inuit, and Métis. So about self-determination and self-government, what is this emphasis in here? And I think some of this, we use the word self-determination quite a bit, and in government I'm asked a lot about, well, what does this really mean, and practically how does this work? What does it actually, how does this play out? So what I often say is that in recognizing Indigenous peoples that have the right to self-determination, they very much have the right to develop their own economic, social, cultural, and political development. And that very much leads to Indigenous peoples governing their own communities in the way they want, as opposed to being subject to the Indian Act or any other type of regime that's related to that. And in governing their own communities, Indigenous communities have very much jurisdiction over what and how decisions are made. So they have Indigenous jurisdiction. It means they also have the right to participate as partners in the economic development of their territories. Think in a modern treaty context, in a self-governing nation, this means a right to consistent and effective implementation of self-governing agreements. So here we have a little bit of a point where the UN Declaration is very much helping us to recognize not just Indigenous jurisdiction in decision-making and lawmaking, but it's also kind of nudging us towards a space where Indigenous government is going to be recognized as part of our broader society and as part of governance, Canadian governance in general. But I think one of the key things about this too is, again, it's one thing to recognize what all these rights are. It's one thing to recognize and say what these all are, but I think it's a very key and pertinent question for government today in terms of how we enable the exercise. What are the active, positive obligations we should and could take in order to enable the exercise of these rights? So very recently, my minister has publicly talked about a framework, a little bit of a recognition of rights framework, and what this is meant to do for us. So I think, again, this is the point at where we look at the UN Declaration, we say, is it a tool or is it a distraction? One of the things that I think is understated about the UN Declaration is, if we're going to move forward, if we are going to commit to this, how is it that you and all of us can enforce government to take action under the UN Declaration? What commits us? What are the monitors we can put into place? What are the ways we can measure progress going forward? So the UN Declaration, as with the principles, as with everything else, it's not a tool all by itself that can do all these things for us. It needs other tools. It needs comprehensive mechanisms for implementation, just as every self-government agreement needs consistent and effective mechanisms. So too does the UN Declaration. So too does our commitment to move forward in this. So some of the key policy questions that I think we have going forward, and I kind of balk at calling them just policy questions, because I think they're questions that we all have to face, that we're all going to have to come up with answers if we were really going to hold ourselves and commit ourselves to the aims of not just the UN Declaration, but to the aims of the commitment that this government made. So some of those questions are, how do we ensure that there is space for the operation of Indigenous jurisdiction and law in our society? How do we ensure that there are areas of co-decision making and that these areas are clear to everybody? How do we ensure also that there is a fiscal relationship that is designed to support the operation of an Indigenous government, both self-governing and those who want to be self-governing? And also, how do we support institutions that Indigenous peoples have created and may want to create in order to support this work going forward? So I think I'll leave it at that. I think lots of interesting questions in times ahead, but I think, again, my message about whether the UN Declaration is a tool or a distraction, at the end of this, I have to say it is a tool, but it needs other tools, and it needs strong enforcement to be a very effective tool. Thank you.
Thank you, Mrs. Kwan. We just have another round of applause for all the four speakers. I think they all gave excellent presentations. Now, we do have, all speakers were pretty much right on time, which is great. So we do have about 20 minutes for question and answer period. If we have any questions out in the audience, we have 3 microphones set up. Just please step up to the mic if you'd like to ask a question to the panel. We have a question in the center mic there. Go ahead.
Excuse me. I'm Chief Kirakwandi, Asnuiti Neo Nation. In English, it's Lake Cree Nation, and I am Cliff Callio. I live in northeastern British Columbia, Treaty 8 territory, but I'm not a signatory of treaty. But I've been in litigation with the Government of Canada for 22 years, and it's been awful difficult through the struggles of consultation and recognition and all those little games the bureaucrats play when they come to the table. And the first question they always ask, are you a collective? Well, if you weren't a collective, we wouldn't be able to sue the Government of Canada, even though you're not a registered Indian under the Indian Act. My question is, as a nation that has Indigenous laws, that uses Indigenous laws to govern ourselves, and we have a governing system, and all those instruments that go to become a nation, you know your history, you know your language, you know your culture. 3 elements of becoming a nation that, you know, all those things that, and then you use your other laws that are that are applicable Indigenous laws to govern yourself and make decisions on those things, which is, you know, all the instruments. Like some of it was talked about today with one of the litigators or the lawyers from BC, but we have all those things in place and been practicing those things since time immemorial. What the problem we have is that, you know, when every time we go talk to the government, they say, well, we can't talk to you because you're suing us. Well, I don't think with the UN Declaration of Rights of Indigenous People has some kind of flexibility where we can start dealing with some of the necessary instruments to be able to work with our nation, to be able to have some capacity to do the work that needs to be done to get our objective is why we're here today, or yesterday and today, is to be able to not sign Treaty 8, even though we live in Treaty 8 territory, but to sign a modern-day treaty, a fiscal relationship, a relationship with the Government of Canada. My question is direct, why is it that the government, the services there, that we can't get services like education, training, culture, and all those components, and to do with the necessary process that needs to take place without, and we can still go ahead and use the court system to argue on some of the things that the government, I guess, is trying to say, you know, like they use all kinds of arguments against this, but anyways, it's not going to be a very difficult, or it's an easy process for us to be recognized because we've been there in this land before Confederation and before all those instruments that go into place, before the province of British Columbia, before the province of Alberta, because we live and right at the border of Alberta and BC, so our territory, our traditional land use goes into both provinces, and it's been difficult to try to get someone to listen to us. And on the consultation part, all we get is notices. And usually the government says, well, you could talk to those people if you want to talk to them. You don't have to talk to them if you don't want to. So, but we've been successful in talking to industry and getting some opportunities. So that's how we survive, is through economic development. We don't get any government funding whatsoever. So, but you know, there is a Head Start process that can happen here. We could start just like any other First Nations that's out there. We've lost, not all of our nations lost our language, but there is the younger generation have lost their language, and because of the lack of infrastructure within our community, and it's always been difficult to maintain that. Language, those kind of things can happen where we can come in and start teaching some of the culture, the language, and all that with the help of the government, to recognize that, you know, these are real people. They're not just some people that are stragglers, or whatever you want to call them, in a perfect language, but these are people that lived in this community, in this land and still live there and still maintain their whole way of life. They still trap, they still hunt, they still pick medicines, they still go harvest berries. They still do all the necessary things that everybody else can do, like, you know, making moose hide, making crafts and all those kind of. We still have that whole structure in place. So I'm trying to get some answers your last 2 days of how can our nation be accommodated. And if you look into your, we've written to ministers, we've written to Bennett, we've written to Jody Wilson, the Minister Wilson, Miss Wilson. We've worked, now we've got some other people helping us. So therefore, if you can find some answers for us, we'd be very happy.
Thank you very much, sir, for those comments and the questions. We will start with Lorraine. She'll provide some answer and some comments back to your question, and any other panel speakers that want to add to it can do so after Lorraine.
Yes, Tansi Washaya. Thank you for those questions and the comments, and I think it relates to something that Professor Brenda Gunn was talking about, which is, so if you're thinking about it from what kind of tool is the United Nations Declaration on the Rights of Indigenous People in that situation you're talking about, I think there's some very practical implications. You're right, I mean, you're describing this outrageous situation in Treaty 8, which has been separated by the interprovincial and territorial boundaries. So you have Treaty 8 people over 4 jurisdictions, BC, Alberta, Saskatchewan, Northwest Territories, who are in very different situations and where rights are recognized in different ways in each jurisdiction. And Dr. Gunn talked about how the United Nations Declaration points to the fact that there should not be discrimination as between the treatment of Indigenous people. I can't think of a more tangible example of how that plays out than in the Treaty 8 context, where you have some Treaty 8 people who are in modern land claims areas who can benefit from all the infrastructure, resource development, sharing, revenue sharing mechanisms, supports for education, land control, co-management of resources on one side, and then in another jurisdiction not have any of those rights at all. It's a real patchwork. You know, another, I think, really clear example of how that plays out in very tangible ways that affect the human rights of people at a very core level is the example that we see in the James Bay region, where you have modern land claims people on the Quebec side in the James Bay Cree communities who now have had the benefit of almost 40 years of this sustained development that's possible under a modern claims process, and the absolute grinding poverty and social conditions in the Cree communities on the Ontario side. It's immoral. There's no reason there should be that kind of discrimination within Canada between how Indigenous communities get treated. It's a real problem. That socioeconomic gap is growing. Like, the statistics show that there's benefits rising now under the modern claims areas that are increasing the gap compared to this, for instance, some of the historic treaty areas. So I think you're pointing to some really important questions, and I think the practical implication is there needs to be more consistency in how the state and the federal government and the territorial and provincial governments deal with these situations, to say, you know, if these things like supports for education, sharing of the revenue from resource development, the obligation for impact benefits agreements, all those other things that are applicable in the modern claims areas are a good idea, why are they not a good idea everywhere else? You know, there's no good reason for that. And just one other fast comment, you mentioned about the fact that you're being told that while there's litigation happening, that there can be no negotiation. That is such a common malarkey. I was going to use a different word, but negotiations happen all the time in parallel with litigation. I mean, I'm dealing with cases right now where that's going on. It happens. You're using different levers to try to get to an agreement and a meeting of the minds and figure out resolution. So that's another practical implication of the United Nations Declaration principles. Like, if there is a commitment to that reconciliation process with Indigenous communities, then stop spending hundreds of millions of dollars in litigation and get to the table and address these issues in a negotiated process. I say that as somebody who does litigation as well. You know, it's an expensive, awkward, not always good tool. It doesn't build relationships. Litigation does not build relationships. So stop it. You know, that's my response.
Hi, I'm sorry, I may not be able to answer your question directly, but I really thank you for the comments and for the issues that you've raised. I think my responses just relate to, I really appreciate that you started the comments with the reference to Indigenous laws and the way in which your nation is governing itself according to Indigenous law. And I think this is a point that I'm not sure I made that I do sometimes raise, is one of the ways in which I think the UN Declaration is a tool is the way in which it recognizes the inherentness of Indigenous peoples' rights as being grounded in Indigenous peoples' laws and territories. And so even though I called for sort of equality and, you know, making sure that there aren't the distinctions, and Lorraine highlighted that in her comments to you, I think it's also important to recognize that implementation of the UN Declaration and the rights as a framework in the specific local context requires that recognition of the existing Indigenous laws. And so I think in that way, your nation is well positioned to sort of move forward with that implementation, which leads me to my second comment or response, is that how do we move forward from this position where government claims to be in a mindset of rights recognition and moving away from proving rights, yet we see a perfect example, I think, here where there's still, at a minimum, hesitance to engage in these processes until the rights are proven. And so my only response or hope would be that the government, as it's moving forward, understands how you need to change on the ground, which means a community is governing itself according to its own Indigenous laws just needs to be recognized, and the government can just sort of take that as the starting point and engage in that process and move away from that rights proving phase of the negotiations that seem to protract things to the 20, 30, 40, 125 years. How many years is it since Treaty 8 was negotiated? So sorry that I can't answer it more directly, but thank you for your comments.
So I can only comment at a higher level rather than sort of the specifics of your situation, Chief Caillou, but I think that what you raise is so important because we look at the history of the UN Declaration. The majority of Indigenous peoples around the world are in a somewhat similar situation as Kelly Lake Cree, in that they are not recognized by the nation states that have, you know, assumed control over their lives, and their existence may in fact be denied. So that many of our colleagues who came to the UN Working Group from countries across Asia, for example, did so at great personal risk because of the hostility of their national governments. And I say this only to set the context that the UN Declaration was not a declaration of the rights for those Indigenous peoples who are recognized by the state. The Declaration is explicitly a declaration of the rights of those peoples who identify as Indigenous peoples, and it affirms that right of self-identification, and part of the state obligations is that obligation of recognition. And I think it was really important to hear from Diana Kwan about the recognition that the Declaration sets out positive obligations for the states, that there's a responsibility to actively promote and protect the rights of Indigenous peoples, as there is with all human rights. And I think that that's part of the key to understanding the Declaration. It's also important to understand it, as Brenda Gunn said, that it is an anti-discriminatory framework. It's a framework to repudiate and to address discrimination. So, you know, situations that, as Lorraine Land said, set up a discriminatory situation for one Indigenous people in respect to another, you know, have to be resolved and addressed. But I think the third principle I'd emphasize in the Declaration is that of remediation or reconciliation. The Declaration, in beginning in its preambular paragraphs with the repudiation of colonialism, says we also can't just accept the status quo that exists today as a context of colonialism, but rather we have to actively undo it and set things right for those who were deprived as a consequence of colonialism. I mean, sometimes I hear government officials, I've heard this at the provincial level as well, to say, well, we'll look at this on a going forward basis. Well, that's not the intent of the Declaration. The intent of the Declaration is to set right the consequences of past harms, including the denial of people's very existence.
Thank you, Chief. Thank you, Chief, for your comments. They're very eye-opening for sure. I think what you point to is certainly, it's a human rights issue for sure. These are human rights issues that have been faced by Indigenous peoples throughout the entire history of our country. It's a very unfortunate history, of course it is. And I think this is also one of the things that the Prime Minister himself actually spoke to when he addressed the UN General Assembly towards the end of September. He did say at that time there's definitely more that can be done, more that we should be doing about Indigenous peoples and Indigenous issues in our country. And I think one of the other things, too, that I point to, particularly with your highlighting of your history, your culture, you do know your history, you do know your culture, you do know your laws, you do know your language. I'm a first-generation Chinese-born Canadian. I can barely speak Chinese. I can't even write the characters. I know 10 characters in my name. But to have that kind of resilience, I think in Canada we have a ton to learn from, and we can do so in partnership and certainly in collaboration. So you had also said the issue about litigation and negotiation and why we can't speak about these issues if we're in litigation. I think one of the things today that we see emerging is a more of an openness to talk about things, even though we are in litigation. So CERNA, my colleagues at CERNA, have what are called exploratory tables. There's a whole new acronym for them that I never get right, but they're often known as the Joe Wild tables. So a lot of these tables, too, have emerged from litigation. There is an openness to talk about other issues that are in play that aren't specifically related to the litigation, and all of which to say is there is a possibility to do both at the same time, for sure. So I know the progress is slow, but step by step, I'm hopeful that we'll get there. And I think one of the other things that I'll say about this, and I know there are other questions around this, one of the other things I'll say about this is one of the recent studies that I looked at, and this was put out by the Center for the Study of Living Standards. They said that if we, as a society and as a government, spent the money closing the socioeconomic gaps, addressing the human rights issues, addressing the labor market gaps that Indigenous peoples face, we would actually inject our economy over the next 15 years, $36 billion. So when I think about the cost of doing nothing for the next 15 years and the cost of also just maintaining the status quo over this very long period of time, I think I'm very safe to say that we've undermined ourselves on a grand basis, as well as created huge human rights issues in our country.
Thank you for that. We only have about 6 minutes left, and I see 2 gentlemen at the mic. So we do have time to take a couple more questions, but please just keep your questions brief. We'll start with the gentleman to my left to see who was there first, and then we'll move to the gentleman over here.
Thank you, and thank you for all of your words and the opportunity to learn and understand. Michael Kerr, I teach at Seneca College in Ontario, but most of my life is taken up helping to coordinate a coalition called Color of Poverty, Color of Change, which is a bringing together of Indigenous peoples and peoples of color to develop common cause, solidarity, and common objectives when and where possible and appropriate for racial justice change making. With that in mind, and when you think 2 weeks ago with one of the most recent releases of StatsCan data that showed that 22.3% of the population of Canada are now peoples of color, many of whom have histories of experiences of colonization and colonialism in countries of origin and other experiences of racism in Canada. How might we be better able to more fully engage that large constituency of folks to be stronger allies in moving forward with full implementation of UNDRIP?
Thank you for your question, sir. Just due to time, perhaps the presenters can decide on who wants to take a... Oh, sure. Okay, well, the do you want to hear both questions first? Okay, we'll come back to your question. We'll hear from Mr. Dragon there.
Thank you. Just trying to how to preface this. I think, when we look at the legislative framework around this, hopefully, as compared to another policy. And that's the thing that I'm stuck on, is the policy. If we're going to use UNDRIP as one of those tools, and those practical implications in terms of this, somehow I think we need to get away from policy and make this a piece of legislation. So we're 10 years since it originally started, 10 years behind. And then I look at yesterday's talk with the splitting of INAC, Indigenous Services, and then I think of the Department of Fisheries. We look at INAC as being the largest of the departments but I think Department of Fisheries is just as bad as INAC in terms of this. So in terms of another policy or legislative framework, what do you think? How do we move this along quicker than it just being another policy? We had just come from meetings in British Columbia with fisheries, and even the regional directors of fisheries don't have any clue about what UNDRIP is about. They haven't got any direction from Ottawa on it, so I'll just leave that with you guys.
I'll take a quick stab at responding to the first question, comment. I agree that there are communities that could be great allies in the work that we're doing ahead. I do know of a couple of good examples in Manitoba. One of my colleagues at the University of Manitoba is a specialist in refugee law, and so she held a fairly small gathering in Winnipeg in, I think it was the spring, where she brought together newcomers to Canada and Indigenous elders and peoples from the local area. And it was a day and a half of an exchange and time to sit together and learn from one another. And so I think those are really important opportunities. One of the challenges to that work has often been that people just tend to work in their little areas of expertise and in their little bubbles. And so when I work with the treaty elders in Manitoba, they're always saying they want to speak to the newcomers. They want an opportunity to sit down with some newcomers to give some of the context to the territory that the newcomers find themselves on. But the elders don't know how to access the newcomer community. And I work on Indigenous rights in my province and internationally, and I don't also have the context. So I think part of the work is finding the people who can actually figure out how to bring those two communities together. I know the elders in my area would love the opportunity to sit down with newcomers, but someone needs to facilitate that. And so I think, Michael, someone from your organization reaching out to the elders in the area that you work in. Sorry, I've lost you in the room, Michael. I don't know where you... Oh, there you are. We also have really bright lights in our eyes. There you are. Hi. I think, someone perhaps like your organization who could reach out to the elders and who may have contacts in the newcomer community and providing that space, and just for that dialogue to start, I think would be really valuable.
Thank you. Unfortunately, that brings us to the end of this session.